All right, good morning. We'll be back on the record. This is our fourth and final case of the morning. We've switched out panels. I'm Dan Traver. I'm the Chief Judge. I'll be presiding. To my right, your left, the Honorable Jared Smith. To my left, your right, the Honorable Joshua Mize. This is Battaglia versus Battaglia, case number 23-1658. We had an oral argument on this case in April, and we issued our PCA that exact same month. Based on post-dispositional motion practice, though, we determined that we had misapprehended a stipulation we believed that had been accepted at our last oral argument. And based on that misapprehension alone, we have reset OA for today. In our notice, we advised the parties that the OA today is limited to the damages issue that is raised in issue 2 of appellant's initial brief. More specifically, the panel is interested in the argument raised on pages 59 and 60 of the amended initial brief, which is section 2C2, and which relates to an alleged double recovery on the part of the trust. This is addressed on pages 40 through 42 of the answer brief and page 27 of the reply brief. We also asked the parties to be prepared to discuss section 607.750 of the Florida statutes. Nobody here needs reminding that we are not an evidentiary court. We don't weigh credibility. We cabin our proceeding to the record that's before us. That said, we wish to highlight our intention not to consider any matters that fall outside the voluminous record that we have now twice reviewed, and we expect counsel today to abide by that intention. Mr. Brownlee, how much would you like for rebuttal? Whenever you're ready, sir.
May it please the court. My name is Mike Brownlee. I'm here on behalf of the appellant, Phil Battaglia. And Yogi Berra once said it's like deja vu all over again. Here we are again. Kidding aside, want to thank the court really for taking the time to do this again. I know how busy the court is. I know how precious argument time is. I know two of you have traveled a long way to come here. Really, really appreciate it, trying to get this right. It's really important to my client, obviously, so thank you. So we're here to talk damages. Our position remains the same. Damages award should be vacated in full because it is exclusively predicated on corporate actions or inactions and not on trustee duties. And that's prohibited under Parker versus Schulman, which is 906 Southern 2nd, 1236, and the other authorities we cited in our brief.
So let me take the big ticket items first as it relates to the BFCIC and BPL money. So you've got a factual finding in the judgment that money is sitting in the BFCIC and BPL accounts. So is your argument going to be that money effectively is eligible by the result of the trial court's, the rest of its judgment, which I know you disagree with, but we're not hearing about today, that is effectively going to be covered so that any subsequent judgment collection on those dollar items would effectuate a windfall on behalf of the opposing side in the case?
Well, certainly. But I mean, I think the threshold issue is that those are corporate funds that require corporate actions and, the whole panoply of rights under the corporate statutes that were never at play in this case because this was a trust case. There was no corporate.
There's two issues in my mind. There's that, right? And I get your argument on that these were not damages for the capacity in which he was sued, right?
Correct.
The separate argument is, regardless of whether these damages relate to this capacity, they still have the money, right? Like, just as a factual matter, the judgment found the money is there.
Correct. No one's out. No one's out anything.
Which of those two issues is the much easier issue?
I think the first one. I mean,
Really?
I know the court is interested in the second one.
Really? That's easier than the money's still there?
It is in the sense that there was no corporate anything pled or proven to the case. The first time that we realized this corporate stuff is happening is in the final judgment. So, I mean, should never have been even at issue.
But what I'm saying is the capacity in which he's sued is a legal issue on which we must decide, right? And the two of you dispute it.
Right.
The final judgment itself found the money's still there.
Right.
You don't agree?
So there's no damage to the trust.
Exactly. Right.
Okay.
There is no, regardless of what capacity, these actions were committed in or how we would resolve that legally.
Correct.
The money is still there.
Correct. I thought you were going down the road of satisfaction or something like that.
No. I'm just
100
saying there
100%.
are no damages because the money is still there.
Yes, the statute requires really clearly that there be damage to the trust, either a loss or something that can be restored.
Yes. So okay, now that you understand what I meant by that,
Understood.
between those two issues, is that not the easier issue? Before you get to the capacity of damages, the money is still there.
Correct. The lack of damages to the trust, i.e., there's no money lost. That's been our argument this whole time.
I want to ask about, unless anyone has any more questions about those items, about the smaller ticket items, the attorney's fees and the interest on the attorney's fees.
Sure.
Did you take a look at 6070750?
I did.
So I went down a rabbit hole on that. And what I found is that it is, because I think you recall at the last oral argument, I asked both sides about how this works under traditional principles of corporate law, right? And the fact that these are in fact distinct entities.
Right.
And I went down a rabbit hole on that and found this provision, which seems to be wholly unique to Florida. I can find this I can't promise I scoured every inch of every corporate code, but I did a pretty deep dive. And this subsection B, I cannot find in any other state's corporate code.
Right.
And when I went to look what it was actually, before it was in the corporate code, it seems like it was just invented by courts that made Florida, judicially created, right or wrong. The judiciary created this provision that really set us apart from how traditional corporate law works in every other state, right? And how you would view it. And then what happened was the legislature codified it, right?
I think correct.
That brings into play the prior construction panel and the prior construction canon. And if they're codifying judicial language, you take it to mean they're pretty much trying to codify the cases that use that language. So I'm not saying that this is consistent with traditional notions of corporate law. I'm saying that it appears that Florida, rightly or wrongly, may have created some very weird exception to traditional notions of corporate law, and then the legislature, in their judgment, codified it. And when I went back through the history of this provision before it was codified and all the cases where it was created and then applied, it seemed to be relevant to these types of situations where somebody may owe a duty in two different capacities, and normally you would split those capacities and say they're distinct. But with this particular provision and how the courts interpreted it, before it was codified, how they created it, that if some corporate officer owed you a duty from some other capacity unrelated to their corporate capacity, that would color how they would have to answer their corporate duties, perform their corporate duties, and potentially could make you liable under that other duty. I don't think that's relevant to the double recovery because the money's either there or it's not, and the final judgment sounded there. But it would seem relevant to me to that $150,000 and the $3,000 in interest. So can you tell me what you found on 6070750?
Sure. I concur that it's a weird statute, and I think it's designed to be an end around the derivative suit requirements. That's the best sort of guess I could do by the reading of it. But there are two really good reasons it doesn't apply in this case, or shouldn't. The first is the procedural history of this case is really important to remember. So they sue in a 3-count complaint. First count is for removal as a trustee. Second count is for breach of trustee duties. Third count is against BFCIC and against Bill as in his stead as a corporate officer and director, challenging his corporate decision-making.
I think what you're going to say is they didn't sue him as a corporate officer, but that's my point. This provision seems to say you can sue a corporate officer in some other capacity,
right? Okay.
Because of some other statutory duty.
Correct. But here's what happened. In response to that complaint, we moved to dismiss count 3, the corporate stuff, for failure to file a derivative action. And in response to that, Bob did not turn around and say, hey, this 6070750, it allows us to do this. We're good. He filed.
They're appellee, right? We can simply coach them. I mean, this is a purely legal issue.
That would, Judge Mize, that would be respectfully a huge violation of due process, of my client's due process rights. Here's why. Because when we move to dismiss for failure to file a derivative action, they don't say this statute helps us or we're allowed to do this under this statute. They file a notice, and it's on page 265 of the record. They file a notice of abandonment of the claim against involving all corporate stuff.
They needed that claim. And what I'm saying is that this provision seems to indicate they did not need the claim against them in his corporate capacity. And I think what you're saying, that they could actually do this in his trustee capacity. Like, I agree, it's a bizarre provision. I could find it in no other state. right? It seems to completely be counter to how we think of corporate law. It's in there.
Judge Mice, throughout the case, I'm sorry to interrupt you.
No, go ahead.
Throughout the case, every time my client tried to defend anything he did at the corporate level, there was an immediate objection from Mr. Spivey saying, this isn't a corporate case. Corporate actions aren't relevant here. Sustained. There were 3 pretrial rulings from Judge Jordan that said, this is not a corporate case. This is a trust case. Only trustee duties are at issue. So if we're going to come back now and read into the record something that allowed them to bring up all this corporate stuff, we didn't have a chance to defend.
Well,
It was never an issue.
I get your concern about due process. What that would essentially mean is that if an appellee didn't raise some legal argument below, that they can't raise it with us. And that's just not what the Supreme Court's Tipsy Coachman jurisprudence says.
Judge Mice, that would be a massive violation of the party presentation doctrine. This court cannot be standby counsel for the appellee. And
Well,
Mr. Spivey is paid.
The party presentation applies to the appellant, not the appellee, right? There's a slew of cases from the Supreme Court and across the DCA saying not just that we should, but we must affirm if there is any basis in the record, right? And now, oftentimes that's not clear, right? Maybe you need a factual finding, maybe you don't. What exactly is supported by the record? Here, though, this is a purely legal issue.
No, Judge Mice, if someone had said, in this case, this statute allows us to do what we're trying to do, there would have been findings. That would have initiated the business judgment rule under corporate law. That would have allowed my client to take an advance of his legal fees. That would have changed the entire scope of litigation. No. Tipsy Coachman requires that it be in the record, established in the record. This is the opposite of that.
Mr. Brownlee, I think what you're taking is if that had been the track they took, then we would have gone down the corporate duty route, and this would have been a corporate claim.
Correct.
And I guess what I'm saying is this provision, which I stipulate, is very weird, totally unique to Florida, and out of step with how corporate and derivative actions seem, how we normally think of them working. Okay, it seems to say you can go after corporate duties in some type of claim that arises from something outside corporate obligations, such as trust obligations.
But only if. Look at subsection 2. A shareholder maintaining a direct action under this section must plead and prove either. Must plead and prove. The opposite of pleading this occurred. They waived it. They pulled the count back. So the plain language of the statute makes it clear it cannot apply here because it was not pled or proven. The opposite happened. It was waived. They abandoned that claim. They abandoned any effort or ability to defend or prosecute the case on anything involving corporate anything. So the plain language of the statute, subsection 2, it does not apply. Again, based on the arguments we've made throughout the case, in either of the 2 formulations of the damages problems with affirming the damages argument, I think either one works in our favor, and I'll request the remainder of my time for rebuttal, unless the board has any more questions. Okay.
Thank you.
Good morning. May it please the court, Bill Spivey of Greenberg Traurig with Courtney Keller on behalf of Robert Battaglia, who I may refer to as Bob this morning. I think the court at the trial court level got this right, and I think you got it right as well in the PCA. Let me speak relative to this damage issue to a very interesting point that jumps out at you if you go back and read carefully the appellant's initial brief. It's at page 50 of the initial brief. He completely skips paragraphs 82, 3, and 4, I believe, of the final judgment. And that's where Judge Jordan talked about Bill Battaglia having a conflict of interest in that he breached the duty of loyalty. And that's a critical component that would sustain this damage award if you get into the case law under duty of loyalty. And more specifically, if you look at the 2023 Trust Code, section 802G, there's a comment that reads as follows. A trustee whose duty of impartiality would require the trustee to make current distributions for the support of current beneficiaries may not evade that duty by holding assets in a corporate form and pleading the discretion of corporate directors to determine dividend policy. And I think that directly addresses the circumstance that we're dealing with here. Bill Battaglia had manifest conflicts of interest. The record is
So
clear.
you're getting your damages under 736-1002,
Yes, sir.
correct? So you're dropping 1B off the table, I would assume?
Yes, sir.
Okay, so we're under 1A. The amount required to restore the value of the trust property and trust distributions to what they would have been if the breach had not occurred. So I guess I'd kind of harken back, whether you look at it as a double recovery or whether you look at it as the money still being there. The oddity to me is that the numbers match. You know, your argument seems to be placing an identical value on the opposing party's breach of trust as is contained in BFCIC's coffers and in BPL's coffers. Strikes me maybe that argument would have a little bit more traction to it if it were a different number, say $50,000 or $100,000 or $500,000. I struggle with what I think your argument is, which is the trust has been harmed by the exact same dollar number that's available to the trust through BFCIC and BPL.
Remember that we're suing, Bob Battaglia individually is suing. And the money should have
individually and on behalf of the trust.
Individually and as co-trustee
Yes.
of the trust. But the money should have been in Bob Battaglia's personal account through a distribution that Bill Battaglia unilaterally had the ability to implement. And the record is clear that Bill Battaglia dipped into BFCIC and other corporate funds whenever he wanted to. And ironically, I think that the disconnect that brings us here is this partial satisfaction of judgment.
Not interested.
Yeah, counsel. So I mean, what you're basically saying is, well, the money was within the trust's assets, right? It was within BFCIC, and he had the ability to get it to me, and he didn't, right? But that's akin to like, you know, you're in a divorce. We've got a joint bank account. The other person, you know, won't release money to me. You don't get an order for them to, you know, pay you the money personally, and also still get to keep the money in the joint bank account. Like, the money is still there. At least this pot of funds, I mean, you can say he dipped in for other things. This pot of funds is still there, and either it's able to be distributed or it's within BFCIC holding value to BFCIC, right? And thereby increasing the value of the trust by that exact dollar amount.
But it should have been distributed years prior to it still being there. And it should have been in Bob Battaglia's account.
Take the joint bank account example, right? You're in a divorce and you say, Judge, the spouse should have given me this $1 million 2 years ago, right? Or 5 years ago. He or she has been holding up the money. It's my money. And if the judge said, okay, the judge wouldn't say, yes, pay them your half of that money personally, and also you get to keep the half in the joint bank account. Like this, nothing you're saying, you know, does anything to deal with the fact that that money is still there. It's within the assets of the trust, and when distributions happen, that money will come up.
But it should have happened much earlier, and it should have happened without litigation. And the defendant should not be able to now come forward, oh, there's no damage because I sat on it for 5 years.
He's not saying there's no damage. He's saying you're getting double damage by getting a personal payment and also the money still being within the trust. Nothing you're saying to us is responsive to the fact that this results in a double recovery. The money is still there.
I think if the statute spoke more towards penalties as opposed to restoration of value, maybe this would resonate a little bit more. But if I'm just looking at the plain language of 1A, it's not talking about bad co-trustee. You know, you should be penalized for this. It seems like if you're making a time value of money argument, that wouldn't be the entire to the penny amount of that value.
Of course not. But if you look at the statute, 1002A1, it says restore the trust distributions to what they would have been had the breach not occurred, including lost income that would have resulted from proper administration. And the record is clear that Bill Battaglia engaged in gross trust administration.
But counsel, what stops that distribution from still happening?
It theoretically could in the future, but it should have happened 5 years ago
Okay.
voluntarily.
If that happens, will your client get a double recovery?
No,
How? He got the money from Bill, and now he's also going to get the distribution for the same amount. How is that not a double recovery?
we haven't gotten any money from Bill.
Okay. If you were to be able to enforce this judgment in the manner you're arguing, don't avoid the question, and the distribution happens, will your client not have gotten the same money twice?
Not necessarily. I think the judgment is against Bill individually because of his misconduct. And now I think you are saying, well, just dip into the corporate funds and then you'll be fine.
But this pot of money was, these are the corporate funds I should have received. Is it
Yes.
not? Okay. So the funds to which that is referring are still there. So if he receives them through a distribution, albeit late, right? Maybe it doesn't happen when you say it should have happened, but those funds ultimately will have come up to Bob. We're using first names because they share the same last name. They would have come up to Bob, and also he would have gotten those same corporate funds from Bill, would he not?
I think that's right, Judge.
Okay.
I think you're right.
So there's a double recovery here.
There could be a double recovery. There could be.
If the money does not come up through a distribution, it's still going to be in BFCIC, correct?
Yes, sir.
BFCIC is an asset of the trust.
We
Or,
own,
you know, the shares of it was 77%.
We own 78% of it,
Yeah,
yes, sir.
78% of it. If a company, if you have one company and you have the same company with $2 million in its bank account, is that company worth $2 million more?
I'm not sure I'm following you. I'm sorry.
You have one company, whatever the status is, whatever assets it has, same company, only it has $2 million in a bank account. Is that company's value $2 million higher than if it didn't have that $2 million?
Yes. Yes. I don't know if you have any other questions of me relative to the damage issue. I think that the ruling below was correct. At a bare minimum, if this court is inclined to reverse on any form of the damages, Bill Battaglia is still liable for at least nominal damages. And there's just not a complete walkaway that he gets from this. There was some egregious misconduct that was adjudicated by the trial court. And at a bare minimum, my client's entitled to nominal damages.
Do you have any thoughts on the corporate code provision that Judge Mize and Mr.
I think it's
Brown were
interesting.
discussing?
I think it's very interesting. My point in saying I think there's another way to get there, and it's 736.08026. And if you look at this 2023 comment on
Can you just give that number one more time?
the statute is 736.0802 subpart 6. And I'm now referring to the Uniform Trust Code comment G under section 802G that talks about a trustee whose duty of impartiality requires him to make current distributions cannot invoke this corporate defense, if you will. And there's other case law that talks of a fiduciary that has a conflicting interest. You don't then get to invoke the business judgment rule. You don't get to invoke these niceties because you've trampled the niceties. When you found it good for you to trample the niceties, you did. So a court of equity will not enable that person to now come forward and go, oh, wait, I need to invoke these corporate niceties. I need to invoke the corporate formalities. You've run roughshod over them for years. You're not entitled to do that. So to answer your question, Judge, that statute is very interesting, the corporate statute, but I think you can get there the same way through 736.0802, which then ties into 736.1002A. 1.
Do you find Mr. Brownlee's plead and prove comment as it relates to the preparatory part of sub 2 to have any value to it? Because it doesn't seem like it was pled.
It wasn't pled. We did not utilize that statute The statute became effective only 6 months before the lawsuit was filed. We did not use it. But I think the concept in it is applicable to this case under the tipsy coachman rationale.
Well, and I'll ask Mr. Brownlee this when he gets back up, but it says plead and prove an actual or threatened injury resulting from a violation of a separate statutory duty, right? So that seems to say what you have to plead and prove is the non-corporate statutory duty, like a trust duty. Anyways, that's go ahead.
But I think the legislation points to the fact that there can be liability in different capacities. And I think that existed prior to the enactment of the legislation. I think under equitable principles and other principles that we allege in this case, you could also be liable for these things. And I think that the lower court got it right, and I think you did too.
Thank you.
Thank you.
May it please the court. Your Honor, so it wasn't pled, it wasn't proven.
Mr.
It
Brownlee,
was literally
if you'd
waived.
rather spend your time on the $2 million, I won't begrudge you, because obviously 153 is a smaller piece of it. So if you want to not use your time like this, it's your time. I won't begrudge you. Okay, but I'm interested in it because it says the whole point of this seems to say you can sue corporate officers for other duties that normally you would only be able to sue them in their capacity as a corporate officer. It seems to say that if they owe you some other duty, you could sue them under that duty, under that capacity for corporate actions. And when it says plead and prove, it says you must plead and prove an actual or threatened injury resulting from violation of a separate statutory duty, meaning separate from the corporate duty. So it seems to say what you can do is bring a statutory duty claim, like a trust duty claim, right? Plead and prove the trust duty claim, but hold them liable for actions taken as a corporate officer, which I agree is strange. I'm not saying it's not a bizarre provision, but it says plead and prove a separate duty from the corporate duty, doesn't it?
Judge Mize, it does, but Mr. Spivey just told you it wasn't pled. They never considered the statute. For tipsy coachman to apply, it has to be established in the record. It is the opposite of that, because when we moved to dismiss and said you have to file a derivative action if you want to talk about any of this corporate stuff, they abandoned the corporate stuff. And it doesn't show up again until the final judgment, which is why we think Judge Jordan didn't scrutinize the final judgment, because he didn't make an edit to it. And all this stuff that he said was not at issue comes up again.
You know, what's interesting about the statute, which I think we've got a plurality at least on weirdness, as it relates to referencing a separate statutory or contractual duty. So in that sense, I don't know, and we ask questions, we don't make suppositions, but to the extent that that's a supposition, that this refers to something separate, contractual to me would seem to be driving the notion that you wouldn't have to plead effectively this end run around the derivative statute, so that you could anchor it in some other form of recovery.
Perhaps, but we don't. There are no findings because none of this was ever argued before. I mean, this is getting we're getting off the reservation for tipsy coachman. This is not what this is.
Mr. Runley, I agree that when you need when something requires a factual finding, we cannot tipsy coach it on that basis unless the factual finding is in the record. I'm with you on that. Okay. But it's not true that we can't tipsy coachman based on a legal argument that the appellee did not make, right? We can tipsy coachman, and the Supreme Court tells, this is good, whether it's a good idea or not, the Supreme Court tells us to tipsy coachman based on legal arguments that were not raised, as long as the basis for the legal argument is on the record. The legal argument didn't have to be made. Right?
I disagree with that. I think the Supreme Court says you have discretion in limited circumstances to do that. And Mr. Spivey, no one said, hey, there's a separate reason for affirmance here. It's a different reason from the court. I mean, we are really far past the party presentation doctrine, which the Supreme Court is, the current iteration of the Supreme Court has talked way more about.
Doctrine only applies to appellants.
That is, I disagree with that, Judge Mize. I do. And we can file, if the court is serious about affirming any of this on the basis of this statute that was never pled or proven, then we would respectfully request leave to file some sort of memorandum.
You're telling me your position is that a appellate court in Florida cannot affirm based on any legal argument not made in the appellee's brief?
I think no, you definitely have discretion to do that. I'm saying there's no duty, and that's supposed to be in very limited circumstances, and it's supposed to be when the appellee points it out to the court. A sua sponte application.
No, but that would mean it's in the appellee's brief, right? What I'm telling you is it your position that if it's not in the appellee's brief, it's a legal argument that's not in the appellee's brief, we can't affirm based on it?
I think there are very limited circumstances where you can, based on my reading of what I know about tipsy coachman. But if this is actually happening, then we'd respectfully just like leave to file a memo of some sort, at least, to convince the court otherwise, since it's coming up now for the first time.
Can I, if there's a,
Please.
I think we spend time on this issue, at least from my perspective. Can I ask you to address your motion for reconsideration of the fees?
Yes.
What is your best case that this changes the, I mean, obviously the bigger issue in the case was removal, it seems like, right? What is your best case as opposed to damages? Assuming that if we were to agree and reverse the $2 million damages award, what is your best case that the fee order should be changed?
It's not necessarily a prevailing party fee statute, right? It gives the court, where you're sitting in equity, it gives the court discretion to take the equities into consideration. We've been arguing since the jump that the damages were not possible. I don't know if, saying whether removal was bigger than damages. I mean, if you have a $2 million damage award against you personally, I think that's a pretty big deal, maybe more so than the removal, but that would make it such that we prevailed on a major issue in the litigation for the reasons we've been saying since the jump, since the trial court level. And there's no reason we should have to subsidize the other side's legal efforts when we win in a major argument.
Two minds on this. In one mind, to me, the major issue of this case was certainly who runs or who has control over this family trust, which had $70 million of assets or thereabouts. And certainly if I, go from the comments at the beginning of the OA today, the issue that we're here back on is 6 pages out of 203 pages of briefing. It's an enormous record. A lot of work was put in on both sides on this. On the second hand, we've made you guys come back for a second argument on OA, and I presume that you guys are prepared for all of that. It seems to me that as it relates to figuring out a case where we have a party prevailing on one issue and a party prevailing on the other issue, we weigh some equities. And I wonder if, given that backdrop of my two minds on this, if you couldn't help me understand which side of my brain I should be listening to.
The side that helps us, of course. So, Judge Schraber, I think when you delineate the briefing, 6 pages of the briefing is on damages. It's a little bit. I don't know that that's exactly right, because a lot of that incorporates stuff about removal. I mean, a huge part of our removal argument was, hey, this is all corporate stuff he's being removed for, not trustee stuff. It has nothing to do with his trustee duties, and that's a big part of that damages argument. So all that facts and all the stuff that we argued removal, I don't know if we specifically incorporated that by reference in the damages argument, but I think we came close.
Well, I mean, if he's not removed, then there's no damages, and that's
right.
Yeah.
Yeah.
So, and I get
so
that.
it just bleeds over.
But there were bases for removal other than corporate other than
there was one, which was a failure to file accountings, which was also Bob's duty.
Well, what I'm saying is, though, that the fact that the fact that he was removed, portions of their claims for removal were related to alleged breach of duties, but there were some reasons they gave for removal that did not pertain to breach duties, just based on lack of cooperation, right? That was when we talked about the last oral argument. So it's not like just the fact that the removal is upheld completely resolves the damages issue on that, right? Because
No, they're different.
You still have to determine whether or not damages came from that would still be a live issue.
Sure. Yeah.
Right?
I was just speaking to the idea that only 6 pages of the briefing were about damages. I don't think that's really a fair characterization of what had to go into the damages argument to get you there. That's all. And also, we're back at the second oral argument, not because of anything my client did. None. So also to have to pay for all that, all their fees associated with this, that's also not fair. I hate saying not fair. It's barred my house, but it's not fair. Shouldn't happen. And if he wins on damages and we're back here because of Mr. Spivey or Bob or however you want to put it, we shouldn't have to subsidize that. We shouldn't. So the court should, whether it's a full scale, reconsideration of that.
Is that theoretically something that could be argued in the lower tribunal as it relates to amount? and
I hope not.
reasonability as opposed to entitlement.
I-
You know, just in terms of thinking about it, and I'll go back to the family law sort of situation again. You know, you can go back and just because you have entitlement ultimately, and I understand that there was an agreement on the trial fees,
The amount.
but as it relates to lower court determination of what the amount is, isn't that what that last part that you just said, the not fair part, isn't that something that the trial court could take into consideration?
I suppose, but that would engender hundreds of thousands more dollars in litigation. I would suggest, if I were the court, let the parties walk away and pay their own fees.
Also, that goes to reasonableness.
On
of
appeal, at
fees.
least.
That goes to reasonableness of fees, which the trial court decides. We decide the equities, correct?
Correct. So what I'm saying is, if I'm deciding the equities and I'm sitting where you all are, I would let the parties pay their own appellate fees. Be done with it. And they don't have to litigate about this anymore. It's over. That would be helpful.
Thank you.
Gunners, thanks so much for your time.
We'll be in recess.